Welcome to this fourth presentation relating to Chapter 5 of our textbook. As you know, this presentation covers constitutional law, and we're about halfway done with our Bill of Rights. Again, this lecture is focusing upon the U.S. Constitution. So let me advance to that section. We've covered the first 5 of the 10 amendments that make up the Bill of Rights, and now we're up to slide 26, which is going to cover the 6th Amendment. So what does the 6th Amendment provide? Well, it is the one, you may recall in the 5th Amendment, going back here, we talked about the fact that there is due process protections. There's that due process clause of the 5th Amendment. Well, the 6th Amendment in many ways is a little bit redundant because it actually makes explicit some of those due process ideas that we see in the 5th Amendment. So these kind of say, well, you know, we talked about the 5th Amendment due process rights, but we're going to tell you some specific ones that we're sure ought to be included. Now, just because some are listed in the 6th Amendment doesn't mean that's an exhaustive list. Otherwise, there'd be no point in talking about due process in the 5th Amendment. So there certainly are rights beyond the due process, beyond the list of the items in the 6th Amendment that also are covered in the due process protection of the 5th Amendment. Let's just look for a second at the language of the 6th Amendment. Here we have it. In all criminal prosecution, so this is important to remember, we're talking about criminal law, we're not talking about civil law. These protections for the most part won't apply in the civil context. So in criminal cases, the accused shall enjoy the right to a speedy and public trial, right 1, by an impartial jury, right 2, by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, number 3, to be confronted with witnesses against him, number 4, and to have an ability to have compulsory process for obtaining witnesses, that's subpoenaing power, in his favor, and to have the assistance of counsel. So we have 1, 2, 3, 4, 5, 6 rights. You may notice here, by the way, a British spelling for defense. So we're going to go through briefly these 6 rights. Again, there's not a lot of applicability with respect to business law, because obviously this isn't a criminal law course, but there is a little bit of applicability, so it's helpful to spend just a few minutes on this. Okay, so let's go with these. We have a right to a speedy trial. Keep in mind that the government has all of these resources available to it. And in fact, when a person has been accused of a serious crime, that person is oftentimes incarcerated to the time of the crime. Even if he is able to make bail, he's probably going to have his ability to travel to be limited, plus he's under this cloud. He doesn't know what's going to happen. He may be treated poorly by the community if the community believes that he's guilty of the crime. And so you can see why, especially an innocent defendant, would want to hurry up the process so he could get that trial. And so speedy is an important protection. It's in the Constitution in the 6th Amendment, but there's also both state and federal laws that provide for a speedy trial. The speedy trial protections of the Constitution and of statute can be waived by defendants, and it's not unusual for them to be waived by defendants. Sometimes defendants want more time to prepare their cases, but if they don't want more time, then the state has to present the case very, very quickly. Of course, what the state can do if the state feels like it's not ready is it can delay the indictment process, because the clock starts ticking once a person is indicted. And so under those circumstances, they can just kind of wait for a more convenient time to proceed. So it's only after the charges become official that that clock starts ticking. The defendant also has the right to a public trial. You might think if you are a criminal defendant that you wouldn't want a public trial. You might be embarrassed. But the idea here is not so much that you are embarrassed, but that this really will permit the public to know what the prosecutor is doing. Let's say the prosecutor is up to no good. The prosecutor is proceeding with this charge for political gain or because of a personal vendetta. Well, the public being able to see it, the press being present for it, allows the shenanigans of the state to be revealed. And so that is the idea that a sunshine will reveal and purify whatever is happening there. So that's why there is the right to a public trial. And then, of course, we have the right to a jury in a criminal case. The idea here is that if you had the judge decide guilt or innocence, the judge is an employee of the federal government, and so he or she might not be as neutral as we would want him or her to be. And, of course, the jury are private citizens. Now, it is true that a criminal defendant has the right to a trial by jury, but he or she does not have to exercise that right. There's recently a case, a young woman was charged with involuntary manslaughter when her male friend committed suicide, and there were a series of texts that were available for the finder of facts to review that showed that she was encouraging him to kill himself, and he in fact did kill himself. Well, in that case, the criminal defendant wanted to have a bench trial, and my guess is that she felt that she stood a better chance of getting acquitted if a judge was considering the case than if a jury. In this case, the judge found her guilty, so it didn't work this time, but it is an option that the criminal defendant has to say, I prefer to have a bench trial or a judge decide guilt or innocence instead of a jury. So that is our third protection. Our fourth protection is they have a right to know what the accusations are. I mean, how can you prepare a defense if you aren't sure if you're being charged with murder or treason or bank robbery or whatever the particular offense might be? And of course, you're going to see those allegations in the indictment. And then again, you have the right to cross-examine the witnesses that are against you. And you also have the right to call witnesses that are in your favor and with the power of the subpoena. And then finally, you have the right to an attorney. When this last right was initially viewed as the right to have an attorney if you could afford an attorney. It wasn't until the 1950s that the right to an attorney was expanded to include situations in which a criminal defendant doesn't have the financial means for an attorney. It's obviously about in Collin County, about 80% of people who've been accused of a crime lack the financial resources to hire an attorney, and so they are provided one by the county at the expense of the taxpayers. But you can see how for those 80%, yes, let's say there was no mechanism in the state to pay for attorneys. They might have the theoretical right to an attorney, but it's a meaningless right when they lack the financial resources to pay for the attorney. Okay, let's move on to the Seventh Amendment. The Seventh Amendment's kind of a quirky one. We haven't talked about this particular permutation except to say that constitutions are usually kind of like mission statements. They don't paint in all the details. They paint in broad brush strokes. They're designed ideally to be timeless documents that will still be a good guidepost 50, 100, even 200 years later. And for the most part, our founding fathers did a good job writing a constitution that would be that timeless document. But of course, no one's perfect, and not even our founding fathers is perfect, because look what they put in the Constitution. They said, let me actually pull it up. Here we go. In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined by any court of the United States than than according to the rules of the common law. So when they say here common law, what they mean is civil cases. And they're saying you have a right to a jury trial in civil cases if it's a federal case, if the amount of controversy is over $20. Now back in 1789, $20 was some coin, right? Now it's maybe you can eat a meal for one at a restaurant for $20, but you certainly couldn't feed a family of four at a restaurant for $20. It's not, if someone cheats you out of $20, you're not even going to bother to sue them over it. You're surely not going to want a jury trial over it. So this is an example of a law that, or excuse me, an amendment that really isn't timeless. It is designed to really be tied to a particular time period in a way that probably doesn't make sense for a constitution. But again, everybody makes mistakes, even our founding fathers. But the general premise that even in civil cases we have the right to a jury is a fundamental concept in both both in our Constitution for federal courts and also in the state of Texas. Let's go on to the Eighth Amendment. Let's go ahead and peek at that Eighth Amendment first. Again, we're still in the area, well, I guess in the Seventh Amendment we veered a little bit from criminal law into civil law, but now we're going to go back to criminal law. Here we have excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. So we have three protections here. Excessive bail would be when the crime is minor or doesn't involve the possibility of someone fleeing from the jurisdiction or perhaps being a threat to other people in the community. Under those circumstances, bail should be reasonable. It doesn't guarantee people the right to have bail. So let's say I've murdered several people. Very likely the court won't allow me to get out no matter how much money I have. So under those circumstances, I might be held without bail. But it's designed so that bail is proportionate to the amount of risk that I have, flight risk and just general risk to society. Similarly, an excessive fines is related to this next one, which is if I'm going to be fined, if the penalty that I'm going to experience is having to do with a fine versus, say, imprisonment, it needs to be proportionate to whatever a crime it is I committed. So let's say I jaywalked. Well, a fine of $100,000 would obviously be disproportionate. And then finally, cruel and unusual. Let me talk for a second about excessive fines. Excessive fines also apply in the civil context. For example, in a civil case, let's say the court has awarded the plaintiff punitive damages in a case. Well, the U.S. Supreme Court has found that those can qualify as excessive fines, even though they're not in criminal cases. And so there can be some applicability there. This is probably the one that has the most importance to business. And then, of course, we have a prohibition against cruel and unusual punishment. Again, this is in a criminal context. This would typically apply to punishments that are physically painful. Or that are intentionally designed to be humiliating. Right now, the jurisprudence of our country does not hold that a capital punishment is a cruel and unusual punishment. So let me just go back to our PowerPoint. So we've talked about bails, we've talked about excessive fines, we've also talked about cruel and unusual punishment. Let's go on to the Ninth Amendment. The Ninth Amendment is an interesting, they're all interesting amendments, I suppose, but this one maybe is a scooch more interesting than others. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. What our founding fathers are saying here is that, look, we've tried to list a lot of really important rights, but we might have left some out, or we might not know about some rights that really end up being important to people. And so just because we left them off the list doesn't mean we intended for them not to be protections. And so don't assume just because it's not here that the person doesn't have the right. And so that's what the Ninth Amendment is about, that people, if they already had the right before the Bill of Rights, they still have that right today. And probably the area that we've seen the most activity with respect to this kind of hidden right is going to be, here we go, in the area of privacy. There is no reference in the Bill of Rights or the Constitution generally that gives us a right to privacy. It just doesn't exist in the Constitution. But if you look at the First, the Third, the Fourth, and the Fifth Amendments, you can see kind of lurking behind those protections a notion that, well, what is the reason that people have whatever rights are that are provided for in those particular documents? Well, in many cases, the reason is that, or at least the argument is that there's an inherent privacy interest that people have. And so combining that kind of hidden background reason in these amendments, plus this Ninth Amendment that says, hey, there may be some rights we didn't talk about, combining those rights have led to the U.S. Supreme Court to find this penumbra right, this right to privacy. The first time that the court really talked about that was in 1965 in the Griswold v. Connecticut case. This was kind of a test case. Some civil libertarians wanted the U.S. Supreme Court to kind of acknowledge this privacy right and also to protect married couples' right to use contraceptives within their marriage. Back in the 1965, contraceptives were in many jurisdictions unlawful, even for married couples to have. It was considered a sinful behavior to try to interfere with procreation in that way. And so what happened in this case was that married couples were selected in the state of Connecticut, because again it was unlawful in Connecticut, and they sued the state of Connecticut as a group as saying, look, what a married couple does in the privacy of their own home in terms of family planning isn't the concern of the state of Connecticut. That's a privacy issue. And we have the right to privacy, even though it's not explicitly stated in the Constitution. We have that because of the Ninth Amendment, and we have it implicitly stemming from these other protections. Well, the U.S. Supreme Court agreed with the Griswolds and found that, yes, this protection actually does exist. And it eventually was extended to other categories of protections. And this little nugget, the starting point, is what led to the Roe v. Wade type of idea of privacy relating to abortion issues as well. So it's an evolving category of the law. Now we are up to the 10th Amendment. Up until this point, I've been talking about the Bill of Rights and in the Constitution generally, and talking about federal law. Now we're going to switch gear. What the federal government can and cannot do, and haven't been talking about what the state government can or cannot do. So we're going to flip a little bit here. We're going to talk about the 10th Amendment. And this says the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. So anything that hasn't been enumerated for the federal government to do, it's still with the states. That's why you may recall earlier I talked about enumerated rights when we were talking about federal preemption. Well, and I said at the time, we'll talk more about this later. Well, this is this moment. Yay. Hopefully it's a good moment for you. We're talking about the fact that if the Constitution says the federal government can do X, then the federal government has the supreme responsibility for that. Remember the Supremacy Clause? But if the Constitution doesn't say the federal government has that power, then not only is the federal government not supreme in that area, it can't act alone. And the states or the individual citizens are the ones that continue to have that right. So kind of a big deal issue along those lines. This is the idea of states' rights. You may have heard about this concept historically. For many people in the southern half of the country, states' rights, especially in the southern half, although not necessarily exclusively in the southern half, states' rights are, some folks understand that as an important factor in the Civil War. Other people feel like other issues such as slavery and the differences in the economies between the North and South were more important issues. But again, whichever one is the most important, certainly this was one that was talked about a great deal, and it continues to be an issue of concern. And certainly it was a concern of our founding fathers. I think most of them would have anticipated that states would have had more power probably than the way that the power of each state probably exists today, just from an historical standpoint. That may or may not be the way we ought to run things today. Reasonable people can differ about that, but that's kind of the historical context. Okay, now we're going to talk about the 14th Amendment. This is a freebie. This is not part of the Bill of Rights. As you can see, it's not one of the first 10. It's number 14. After the Civil War, we had several, I think 3, constitutional amendments. These are oftentimes called Civil War amendments or Reconstruction amendments. The 13th, the 14th, and the 15th. And we're going to talk about the 14th. Let me go ahead and pull up the 14th so we can be looking at it. The 14th Amendment does a lot of super cool things and is a really important protection for lots and lots of different reasons. It's a fairly long, oops, I hit the wrong button here, sorry. It's a fairly long amendment, so I'm not going to read it all to you, but I just want to show it to you so you can see what it looks like. And you can see there are several sections. We're going to focus on the first section. So we'll read this one. All persons born or naturalized in the United States. This language probably was understood by the people who were creating this amendment as primarily referring to African Americans who were formerly slaves in the United States, including the southern United States. Again, this is past I think in 1865 or 1866 or 1867, so really just right after the Civil War. So we're thinking about primarily African Americans, but possibly also Chinese Americans who had immigrated from China and who were oftentimes denied some basic rights. Okay, so let's go on and read this again. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Let me pause here and say, remember we talked about jurisdiction. We said if you're a citizen of the United States, you have to also be a citizen of exactly one state. So if this is saying you're a citizen if you're born in the United States or you're naturalized here. You may have heard of the political movement, or I guess a function of that movement is the idea that sometimes people who are in the United States without appropriate documentation may start a family when they're here. Perhaps they were pregnant at the time they crossed the border into the United States, or perhaps they became pregnant after they arrived. They gave birth to the United States, even though they did not have the proper documentation to be here. That child, because that child is born in the United States, is born a U.S. citizen, and the basis of that right is in this provision of the Constitution. He or she is going to be a citizen no matter what the circumstances were that led to him or her being born in the United States. Now, just because the child is a citizen, that does not automatically confer citizenship to the mother or the father or other siblings. So this is the basis. So people who say, well, we don't like the idea of this automatic citizenship, if they were to change that, they would actually have to amend this particular amendment to the Constitution. It's quite difficult to amend the Constitution, so most likely this isn't something that would be easily accomplished. Let's go on and cover the next sentence. Obviously, this first sentence, while it's interesting historically, it doesn't really have much of a business application. Our next sentence is, no state shall make or enforce, and here we're talking about states as in the state of Wyoming, the state of North Carolina, whatever. So we're talking about individual states. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. So again, this is again pointing to the fact that previous amendments, or excuse me, the first 10 amendments had to do with the federal government. The federal government couldn't affect the rights of individual people. But the U.S. Constitution wasn't really talking about what states could or could not do. But of course, states do have a lot of power, and so there was the potential, and it wasn't just a potential, it was happening, that African American citizens in many states, including southern states, but not just southern states, were oftentimes not being adequately treated. They were being denied basic rights in those jurisdictions. And the federal government had no power to act because the U.S. Constitution didn't provide it any mechanism. But with this amendment, now extending those protections to citizens when the state government violates their rights, this is where they now have this authority. So let's read this again. No state shall make or enforce any law which shall abridge the immunities, privileges, or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law. It changes to a yellow. We'll return to this in just a second. Nor deny any person within its jurisdiction the equal protections of the law. Okay, many people consider this amendment almost a mini part of the Bill of Rights. What this language that extended these protections to state government action did was it caused the first 10 amendments, or really the first 9 amendments, many of the protections that had been reserved for the federal government, things that the federal government couldn't do, it then extended many of those rights to state government action. Not all of them, but many of those rights. And so as a result, that's why the state of Texas, for example, has to give me the right to a jury trial, or it has to allow me to engage in free speech or whatever. Prior to the 14th Amendment, there was no federal constitutional requirement that it do so, although very possibly there would have been a Texas constitutional provision. Okay, so that's a discussion about equal protection of the law. Let's also talk about the strict scrutiny, intermediate scrutiny. Let me go ahead and blow this up. And rational basis test. But before we do that, let me just mention that due process of law part, the part that I put in yellow just a second ago. You may recall the expression due process of law. We talked about that when we were talking about the Fifth Amendment. The Fifth Amendment discussion was when we were talking about it from a criminal law perspective. The 14th Amendment primarily is referring to civil protections against due process. So this provides us with protection in the civil context. And, remember when we were talking about jurisdiction, we talked about briefly the international shoe case, and we talked about how personal jurisdiction in that case, the court has to have personal jurisdiction over the defendant, and if it doesn't have personal jurisdiction, it lacks the authority or lacks the jurisdiction to hear that case. Well, the constitutional basis for it is the 14th Amendment. It would violate principles of due process of law for me here in Texas, minding my own business, to be sued, say, in Maine or Hawaii or Alaska, when I don't have any contacts with those jurisdictions. It would be expensive and a hassle for me to travel to those places, and in fact that wouldn't be fair. That wouldn't meet those due process standards, even if it were a civil case. And so that's where we find that protection, and that's how personal jurisdiction plays a role in the 14th Amendment. But let's return to the Equal Protection Clause, that part of the 14th Amendment. And we're going to talk about strict scrutiny, intermediate scrutiny, and rational basis test. The strict scrutiny, as you can probably tell from the name, is the most strict, the most demanding. It's going to apply to situations in which the government distinguishes people based upon things like this: race, national origin, citizenship classifications. And what that, to be honest, usually means is that if there is a law that treats people differently on these bases, almost always the court's going to find that it is unconstitutional. Let me give an example. Let's imagine that the Dallas Independent School District decided that it wanted to open up a school that would permit only Vietnamese ancestry children to attend. They might think, well, the special academic needs of Vietnamese children are different than the needs of other children of other ethnicities, so we think it would be beneficial to provide them with a separate school. Well, being a Vietnamese nationality would be, depending on how you phrase it, either a racial issue or a national origin issue. And very likely the courts will say, no, you can't have a school that just is for one ethnicity or one race. And so therefore we would apply strict scrutiny, and the government would have to show a compelling interest and would have to show that the way that they are applying that interest is the least restrictive means possible. And basically that means that the government is going to lose the vast majority of times. But there's not just one level of scrutiny, there's another level of scrutiny, and this applies to situations where there are distinctions made based upon gender. That's the main category. And also when the law makes distinctions between the legitimacy of a child. Let me just pause here and explain what that term is. This really isn't a concept that we hear nowadays nearly as much as we would have heard about, say, in the 50 or 60 years ago. This is the idea that when a man and a woman have a child, but they are not at the time married to each other, that child used to be considered in the law illegitimate. Obviously, the child had done nothing wrong, but the idea was that the man and the woman should have been married before they started a family. And so when the child was born outside of a marital relationship, he or she was deemed illegitimate, and you're probably familiar with a word for that situation that is very rude and inappropriate. So I'm not going to use it, but use your own imagination if you can think of it. Anyway, under the law, once upon a time, children into that situation were negatively impacted vis-a-vis their father. They did not have the same rights to inheritance and to support than they would have had if their mother and father were married to each other. And so that is the issue of legitimacy. Obviously, really no business impact there, but there could be some business impact in the gender situation. Unlike race, national origin, and citizenship, where there really isn't a distinction between the skills and abilities and circumstances of people of different races in terms of their intelligence or their strength or things like that, the distinctions don't really make a lot of sense. But with respect to gender, there are some differences. Women, for example, are the people who give birth and who nurse the children. They're the people who might be of smaller size, and there are physiological differences in the bodies of a man versus a woman. And so there might be some reasons that you might make distinctions between how you treat a man and how you treat a woman under law. For example, it wouldn't make sense to give a man a medication that is to prevent a woman getting pregnant, because that wouldn't do anything for the man. And so when there are distinctions made in gender, it's entitled to intermediate scrutiny. And to be successful in this area, if the government is distinguishing between men and women, there has to be a substantial or important government interest. So it doesn't have to be compelling. That's the standard up here. And they must be pursued in a way that is narrowly tailored, okay, which is a little bit more open than least restrictive means. So let's imagine that the Dallas Independent School District wanted to open an academy just for women or just for men, and in fact, I think they've done so. And so that would be reviewed under an intermediate scrutiny paradigm. Then we have rational basis. And if the government always loses with strict scrutiny, the government almost always wins with rational basis. So this is a very low standard. This is all the other cases. So when the government wants to distinguish people in situations other than race, national origin, citizenship, gender, and legitimacy, as long as it can show a legitimate state interest and that the way that the law is going to proceed is rationally related to that interest, then the government is going to say that that is a constitutional way to proceed. Well, this concludes our presentation on constitutional law. I hope this information has been helpful. If you have any questions, feel free to send me an email, come by my office hours, or raise them in class. I look forward to hearing from you. If you have any questions, please contact me, and I hope you have a great day. Thanks so much for your attention. Bye-bye.